we're gonna get started, and happy to introduce the next panel with Rebecca back up here on the stage. Rebecca's a partner at Reed Smith in Dallas. She previously served in the SEC's Fort Worth regional office for about a decade as a senior counsel. Mike Diver is a partner at Katten in Chicago. Mike previously served in the SEC Chicago regional office as a branch chief. Ben Hanauer is with us today from the SEC, where he serves as one of their supervisory trial counsels for the SEC's Chicago regional office, where he's served for almost 18 years. He previously served as a senior trial counsel and senior attorney. Jim Kopecky is also on the panel. Jim's a partner at Kopecky, Schumacher, Rosenburg, and he previously served in the SEC Chicago regional office as a branch chief for 3 years. And lastly is Scott Mascianica. Scott's a partner with Hilgers, Graben in Dallas. He previously served in the SEC's Fort Worth regional office for 9 years, most recently as an assistant regional director. Rebecca, take it away.
Great. Thank you, Jim, and happy to be back up here sitting this time. So we have Insider Trading 360. I wanted to start with our government representative, with Ben here on the panel, just talking initially about kind of the lay of the land under the new administration, sort of what's happening at the SEC level, the commissioner approval level. What can you share with us, Ben?
Well, first I have to share the standard disclaimer that I'm sure everyone's heard a few times today, and that's I'm giving these comments in my official capacity as a SEC Supervisory Trial Counsel, but my views don't necessarily reflect those of the commission, the commissioners, or any of the staff. So I can report that, despite all the changes at the commission since January, a real important area of focus for the new administration continues to be on insider trading. Insider trading has and always has been and will continue to be really a bread and butter area of focus for the commission, and we are going to keep continuing to bring insider trading cases and demonstrating the commission's commitment to bringing insider trading cases. Since the change of administrations in January, the SEC has brought numerous enforcement actions alleging insider trading, and they've really, run the gamut from sophisticated insider trading schemes, I'll tell you about one of those cases in a second, to just more traditional examples where a corporate insider shares information with family and friends with the expectation that they will trade on it. One notable case that was brought under the new administration was the Safi and Gee case brought in Massachusetts in March. The commission charged 2 foreign traders for perpetrating an international insider trading scheme that generated over $17 million in illicit profits. The complaint, which is just really a huge number for an insider trading case, the complaint alleged that Mr. Safi obtained tips from corporate insiders and investment bankers, and then he tipped his co-defendant, Mr. Gee, and another individual. The case involved Mr. Safi, Mr. Gee, allegedly demanding kickbacks from Trader A's trading. The trading occurred in the brokerage accounts of the named defendants, as well as in accounts under the names of other individuals or entities that were working with them. As alleged in the complaint, what make this notable is that Mr. Safi would allegedly leak the non-public information to journalists because he didn't want it to wait for it to come out in the normal course through corporate announcements. I'd encourage folks to read the complaint because it actually really reads like an espionage novel. It details clandestine meetings at restaurants in Paris, the exchange of a bag of cash in a cafe in Vienna, and trips to exotic locales like Hong Kong and Singapore.
It's like a DOJ complaint.
There was a parallel criminal action as well, and the indictment has been unsealed. The case really illustrates how this SEC overcomes challenges, first and foremost in the international space, but some of the evidentiary challenges in this case. The defendants allegedly used disappearing messaging apps like Signal. They allegedly used burner phones. They allegedly used code words to talk about their trading. They would refer to the companies by females' names and refer to it as like talking about like they're going out on dates as opposed to what they were really doing. And it just shows, it's a really good example of the SEC and our partners' ability to root out insider trading even when it's really part of a sophisticated international scheme.
Yeah. And I would say if you're going to use code words, don't put the definitions of the code words in contemporaneous emails that don't disappear.
That's right.
You know, that wasn't their brightest moment.
Yeah, I believe they were even using code words to refer to the burner phones that they were using to perpetrate the scheme. So, and just a less sophisticated case that I just want to note is one we recently brought. It's the SEC versus Hagahat case in New Jersey. And that's just a classic example of typical classic insider trading where the director of a company learned that it was going to be acquired. And so, of course, he tells his brother, his stepdaughter, and some friends who proceed to trade on that information and generate north of $500,000 in profits collectively. And just a nice tidbit from that complaint, it actually cites some of the evidence that we relied on in the form of text messages. And there's one from the stepdaughter who's a defendant in the case who actually refers to her stepfather's conduct as, quote, in an illegal insider trading move. And in the same text chain, she asks the text recipient to delete the chain after they're done talking. So some nice allegations of that will show scienter that's part of that complaint.
You can draw some inferences from that, I imagine.
So given that Ben is limited on how much color commentary he can give, I thought we'd turn to the rest of our panel who are now safely ensconced in private practice and can give us some of their thoughts, and maybe just go in order on sort of what you've been observing from the commission in the last 8 or 9 months or so.
You mean just in the insider trading case?
In the insider trading case.
Right.
A lot of observations.
Right. And I'm sure we'll tackle a lot of different angles on this. The one thing that has been interesting to me in the flurry of cases, recent insider trading cases that Ben generally alluded to, relates to the injunctive relief that the SEC has sought. So all of us are generally familiar as SEC practitioners. The SEC generally seeks standard obey the law injunctions whenever it's seeking injunctive relief against defendants. However, in the 11th Circuit, there's a case, Goebel, that for any of us who worked at the agency would always know whenever there was a reference to a Goebel injunction for something that was filed in the 11th Circuit, where the injunction needed to be specified given the 11th Circuit view that obey the law injunctions do not comply with Federal Rule of Civil Procedure 65. So since the turn of the calendar year and the new administration, what we have seen in several insider trading cases is that despite, or regardless of where the cases are filed, one in Massachusetts, one in Virginia, one in Arizona, that we actually see the narrower injunctive language used as relief in those insider trading cases. Gupta, Thompson, there's one in Connecticut.
And what does that get them? What's that benefit the defendant?
Well, in terms of benefiting the defendant, the narrower injunction will specify in terms of the conduct that's enjoined. Now, I don't think Ben will answer this question about whether or not the SEC would ever bring a contempt proceeding for any violation going forward, but there are courts that have suggested that seeking contempt of an obey the law injunction is a pretty difficult order regardless. So that's just a different trend that we're seeing. Ben, I don't know if you can comment on the changes in the approach on injunctive language, because it's not uniform. We just see it more sporadically.
Well, I think what we're also seeing is it's not just the 11th Circuit. In the past couple of years, the 7th Circuit, right in Chicago, issued a decision called Goulding, which had the same result. And so I think folks would see that our insider trading cases in the 7th Circuit will uniformly seek these more hybrid injunctions that spell out exactly how a defendant can.
That's not limited to insider trading cases, though. That's injunctions across the board.
Yeah, that's injunctions across the board. So I think you'll see in the cases we filed, certainly in the Seventh Circuit, a lot come out of our office, that the complaint and the prayer for relief will actually spell out the exact injunction that we're going to seek and what exactly a defendant can't do. And in the insider trading cases, it pretty narrowly hews to what the law is on what the elements for insider trading in the Seventh Circuit.
It's interesting because when you're counseling a client about whether they should resolve a case, it seems like the injunction or the C&D is literally the last thing. Like, sort of, who cares? Unless there's a statutory disqualification, you're dealing with a registered entity. But, so I might be taking a different approach to this, hearing this discussion about narrowing these injunctions.
Yep.
Jim, what about you?
On the issue of injunctions or insider trading in general?
Insider trading in general.
So my recommendation is you don't do it. It's not worth the risk. And I do want to give my own disclaimer that my views are certainly only my own, and they're subject to change at any time at my sole discretion. They will change depending whether I'm representing the plaintiff or the defendant. So I think, you can talk about disappearing text messages. You can read the Haga-Hack complaint and the Safi complaint, and they do read really well. At the end of the day, they're going to come down to your point. What stupid information did they put in the text messages, and when did they do it? Even the phone, right? In the old days, one of the first insider trading cases I had as a defense attorney, a guy got off of a plane, he was riding next to his CEO who said, we're going to get sold, and then he goes and he calls 3 of his friends, and he tells me when he meets me, he's like, well, we talk all the time, we're best friends. So, the SEC has the phone records, they're like, yeah, they talk all the time, they talk about once every other week, they talked 12 times that night, 15 times the next day. Their trades were lining up with their talk. I'm like, yeah, that's a problem, That's going to be tough to explain. So it's going to come down to the evidence. It really is. And how hard that evidence is to get is not our problem. That's the SEC's problem.
Yeah, and I don't want to make people nauseous bringing up off-channel since we've all hopefully gotten past that. But the disappearing messages, I would imagine, despite what you just said, that does present issues in trying to prove up an insider trading case.
Has the SEC found Atkins emails yet?
I'm not going there.
They disappeared.
Mike, what about you? What observations have you
I
seen?
guess I'm not surprised. I agree with Ben. I'm not surprised that you've got a Republican administration, even a Trump comprised administration or commission, continuing to pursue insider trading cases. I'm old enough now that I've lived through a number of different changes in administrations, and it seems like insider trading is just one of those bread and butter areas where they're going to continue to bring cases. And I guess it also still surprises me a little bit, the level of criminal interest. Mm-hmm. Given how complex these cases can be, you can practice in the insider trading space for a long time and still find yourself trying to work through the elements, at least I do sometimes, and yet there always are parallel criminal cases when you've got big dollar amounts at stake and some fairly obvious facts. So I think it's here to stay.
Yeah, and I can just, add to that, just looking at the litigation releases from the cases that the commission has filed in the past, few months, many of them note the cooperation of the criminal authorities, and you see a parallel indictment filed at the same time. And I think folks should definitely expect the commission to continue to cooperate and coordinate with our friends in the criminal realm to investigate insider trading and hold folks accountable. And we'll continue to make criminal referrals where appropriate.
On this panel last year, actually, we had someone from the Northern District of Illinois and AUSA, and he spoke on the fact that insider trading is just always an area that his higher ups are interested in. It's one juries understand. It's one that people think should be prosecuted. There's just a feeling that it's wrong, and you're kind of getting that benefit, and they can really get their arms around it. But it is interesting how often you see those parallel cases.
Well, the criminal authorities, when they bring it under different statutes. They brought it under the SEC statute also, but Like they just lost that Chastain case because they were brought it under a wire fraud statute and couldn't prove that the information had commercial value and therefore it didn't fit the definition of property.
Yep.
You know, that's, well, interesting. If we have true insider trading, why didn't they bring it under the same statute that the SEC does? Then they also bring it under that section 1348. And these guys, way smarter than me, were breaking down the sections of 10B when we were preparing for this. I didn't even realize there were different sections of 10B. I thought you either traded on inside information or you didn't. So it is, the criminal cases are, I think, way more, it's way harder to prove because of the burden of proof itself. They're frustrating for me when they're on the defense side because the SEC side will get stayed, right? And then all of a sudden I can't get any discovery from anybody. Can't take any depositions, can't get anything done. So they're frustrating in that aspect, but the criminal cases, they seem to lose more of the insider trading cases than the SEC does. So don't you kind of wish, Ben, they'd get out of the way and let you guys do your work?
I'll let the criminal folks speak for themselves on that one.
I like that I, as moderator, promised, to obey Ben's rules on what he could speak about or not, but Jim's just firing questions from that end.
Oh, sorry.
The difficulty in bringing insider trading cases, I think, Scott, that's something you mentioned earlier, and to me, it's a little bit of a counter to while insider trading, I think, is always a priority regardless of administration. I think there are some real differences right now, particularly like in staff size and resources. How do you see the future of insider trading for the next couple of years?
Yeah, it's interesting. I have no reason to disagree with the many people that have been on this stage today already, and even what Ben echoed earlier, that insider trading will be a priority for this administration. I fully expect that. But if you actually look at insider trading numbers over the years, even going back to Trump 1, they're actually much lower than they were when Chair Atkins was a commissioner in the early 2000s. The SEC typically brought anywhere from 50 to 60 insider trading cases a year between 2002 and 2008. 2018, 2019, 2020, you're looking in the 30s. Under Gensler, where, as we were talking earlier, Ben noted that maybe resources were allocated to, I don't know, anything else, and a lot of things. Cases were still pretty low. They were lower than those early aughts numbers. So whether we're going to see something different now that there's going to be more of a core focus on those middle of the fairway offering fraud insider trading cases, maybe that we see more cases that are filed. I'll be curious if that's the case given staff constraints, which I think will be challenging. Also, as much as that we will find individuals who will put the key to their secret messages in recoverable format, there's no question that ephemeral messaging applications are going to have an impact. And these cases have often been proved by circumstantial evidence anyway. So I'll be interested to see, even though that I expect this to be a priority, whether or not we're going to see a significant uptick in ultimately filed cases. There might be a continued uptick in investigations, but in terms of the number of cases that get filed, I'm not sold yet that we're going to see this massive uptick during this administration.
All right, moving beyond the CCM commission level and looking more at the landscape of insider trading cases broadly, at the appellate level, federal district court level, what are some observations or some things that you all are seeing? We'll start with Ben and what he can say in his capacity here, and then move down the line.
Well, I can definitely talk about reported decisions because those are in the public realm, and one that I definitely like to highlight is notable is the SEC versus Brewer case in the Southern District of New York. One, it's notable because the defendant was a former NFL football player who opened his own investment advisory business, I believe even while he was still playing in the NFL. What makes the insider trading case against him, I think, fairly notable is that the SEC got to a liability finding against Mr. Brewer on summary judgment, which I think, as the defense bar would know, that's not the most frequent occurrence in an insider trading case or fraud cases in general, because scienter is always going to be something where the defense can say there's an issue of fact, and very often there will be an issue of fact on scienter. What made Mr. Brewer's case different from that is that he was a longtime investment advisor. And so in the court's opinion, first of all, he had an investment advisory, a consulting firm, and one of his clients was a public company that, as part of his consulting arrangement, he learned that that company was going to be doing an issuance of new shares, and that led him to believe that the price of the stock would go down. And so he traded in advance of that. And so when it came time for the summary judgment stage, there wasn't any factual dispute about, did he have insider information? Did he trade on it? Was there a duty to protect it because there were confidentiality agreements? But I thought the crux of the case came down to scienter. And what the court found was that Mr. Brewer, he had been in the investment advisory business for a long time. And so the court found he was in a unique position. He should really know the rules of the road. He also entered into a variety of agreements that he was able to understand. They said, you can't trade on information you learn in the course of being a consultant to this public company. So based on all those facts, which there really wasn't a dispute on the facts, it was just how the court was going to apply them. The court said, look, there is no dispute on the issue of scienter here, and I will award summary judgment to the SEC. In the past week or so, we moved for remedies in that case. We requested a 3-time civil penalty, which we don't always do, and we think it was appropriate under the facts and circumstances of that case. We requested a hybrid injunction, specifically spelling out not to engage in insider trading, so that may be reflective of some of the current thinking. That remedies motion, I don't even think the defense has filed their response yet, but folks should stay tuned to see how that case is resolved. I know there's another notable case that I think Mike's going to talk about called U.S. versus Sacanel, where we're starting to see defendants raise the Loper-Bright defense to insider trading. And Mike, I'll let Mike tell folks about that one.
Thanks. Yeah, pretty standard sort of insider trading fact pattern. Insider girlfriend, I believe, of the trader had inside information in her capacity as an insider. And Mr. Sacanel traded on the basis of that, or well aware of that. And in litigation, Sacanel raised the Loper-Bright defense, arguing that 10b-5-2, Rule 10b-5-2, Jim.
Yeah, thank you.
It's underneath
I could
10b.
use a backup. What's Loper-Bright?
It's in the Exchange Act. Was that the commission exceeded its authority in adopting Rule 10b-5-2, which sets forth its standards for duty of trust or confidence. And I think the court really dispatched with that argument very quickly. There were 2 main arguments. One was, as we probably all know, Loper did not overturn prior cases where Chevron deference was applied, which is what Sacanel was arguing, that, look, insofar as there's precedent that is going against me, court, you should ignore those. That's not what the Supreme Court said in Loper-Bright. And then secondly, sort of belt and suspenders, the court went on to say, let's assume, let's look at this in a circumstance where we're not giving Chevron deference to the SEC. And Section 10b-5 specifically says that the commission has the discretionary authority to adopt rules such as 10b-5-1 and 10b-5-2 thereunder, and therefore it's Loper compliant. So, but I do think we're going to see more challenges like that. I just think anything that targets rules under 10b, you've got a heavy lift there because it's pretty clear in the statute that Congress gave the SEC the authority to adopt interpretive rules.
Can I ask a question on the injunction thing? I know this, Rebecca, I'm interrupting you. So with Brewer then, if it's a hybrid injunction, he's in the industry, is he still going to be statutorily disqualified?
Well, let me just make sure I have my facts right on that. We also moved in that case for an injunction, not as a follow-on, but we moved for an injunction, a conduct-based injunction in that case, that said Mr. Brewer can't associate with a broker, dealer, or investment advisor. So
they would solve that issue anyway.
So the commission decided to skip the second step, the administrative proceeding route based on the anticipated entry of an injunction, and just ask the judge for it right then and there from the district court. And I think that's something we're not just in the insider trading space, but I think we're starting to see more and more of that.
Seeking a CBI as opposed to doing a follow-on
Correct.
AP? Okay.
Well, you're disqualified regardless of the follow-on. You're disqualified from the injunction. But you're saying they're still now you're gonna start asking for specific injunctions against association? That would clear up the issue.
We're definitely seeing more of that.
That's interesting.
I think you would still be disqualified.
You would, that's what I would think too.
Yeah.
Under a hybrid
Even if it's
injunction.
narrow, yes.
Which is back to my, what's the benefit of the hybrid injunction? But okay.
Speaking of 10b-5, well, going to 10b-5-1, there's, been some recent litigation and appeals on the, future of insider trading plans under 10b-5-1. Scott, any comments there?
Yeah, well, I think most of us are familiar with the case out of the Ninth Circuit, the Pizer case, where individual executive traded in on track ahead of some negative announcements and did it under a purported 10b-5-1 plan. It was the first criminal prosecution for essentially utilizing a 10b-5-1 plan to mask insider trading. What's interesting about that, at least from the SEC side, is that there have been, depending on what you look at least 3 cases over the last, 15 years where the SEC has charged individuals for misusing a 10b-5-1 plan. Going back to the Countrywide Financial case, I believe back in 2010, and then Cheetah Mobile, and then the SEC companion to this case. What's interesting about this case, at least in California, is not so much where it is right now, it's early stages on appeal, but is really more what this means for the SEC going forward. We saw the implementation of new 10b-5-1 plan rules in 2022. I believe they were finalized in 23. So now public companies are subject to Item 408 of Reg SK, so there's certain disclosures that are needed in connection with executive 10b-5-1 plans and also their insider trading policies. So just kind of going back to thinking about trends here, I don't know if Ben's going to comment on this, my guess is probably not, but is whether or not that is going to be an area that the SEC is going to use to mine for potential investigation opportunities there, looking at 10b-5-1 plans, changes in them, potentially violating cooling off periods that are now required under 10b-5-1 plans. Ben, do you want to comment?
No,
I don't think you did. Okay, but I had to try.
The SEC gathers information from a variety of sources, Scott.
Refer to the tips, complaints, and referrals department as well? Okay.
Exactly.
All right.
I don't think you can have any insider trading panel for the last 3 years without bringing up Panawatt. I feel like with this panel every year we've had a new update in that case as it sort of moved through. Any update? Anyone want to kind of give anything recent on Panawatt, shadow trading?
So it's before the Ninth Circuit. I think it's fully briefed. When I think about Ninth Circuit, I think generally, there's a better chance maybe the government comes out on top. I could be wrong, though. To me, though, I think you got to look at the current administration, though, because when this was announced, Commissioner Pierce and Ueda came out with very negative statements about the theory. And given their, history with Chair Atkins, I would expect, regardless of what the Ninth Circuit does, I don't think this is going to be a featured enforcement theory for the next 4 years or 3 years.
Yeah, what's interesting about Panawatt right now, I guess really 2 parts when we're thinking about this going forward. The first is just the unique facts of the case. I can look in the audience and I see, at least a dozen people that have written thought pieces on this, so we all understand, I think, the underlying facts here, but the facts are so unique to this type of theory. The insider trading policy, the confidentiality agreement that Panawatt signed, the very apparent connections that seemingly existed between Panawatt's employer, Medivation, and then the company he traded in, Insight. I think it's a very narrow, unique set of facts, Michael, so that I think that the Ninth Circuit, my predictions, which are, often wrong. I could see them upholding it narrowly because of the unique facts here. The second piece, though, about the appeal is that the Chamber of Commerce, and then a couple of advisor associations filed an amicus brief that I thought really identified a couple of aspects of the district court opinion that are interesting to drill down on and could be potentially concerning. The first relates to materiality. There's some language in the summary judgment and then the post-trial briefing, or the post-trial order, excuse me, where the court suggests that materiality could be satisfied because of a connection or a link between the companies, which is a very opaque and sort of an amorphous and it's really not, it's not the standard for materiality. Ben, you would even agree with that. You don't have to say anything. But and that's actually not even an issue that's up on appeal specifically. They just raised that as part of their brief to say, Ninth Circuit, if you're going to opine on this, please do not do anything other than the standard basis for materiality. The second piece relates to fiduciary duty and the difference between an express and an implied fiduciary duty that could exist. It's definitely worth reading the brief. We don't have time to kind of get into the details of it, but it's very unique in terms of how it can apply to situations like employees who are subject to confidentiality agreements, and how it could look if you expand it outward for investment advisors, for instance, that often deal with wall crossing scenarios and are subject to agreements in terms of what it looks like that they can do with the information and what they can't do with the information. So there are still aspects of the case that I think are interesting to follow, although my expectation is, I think, given the facts of the case, the Ninth Circuit's ultimately going to uphold it narrowly.
Yeah, I feel like Hanauer is one of those, everyone can recite the facts pretty quickly, and I was doing a board presentation about 2 weeks ago to a public company client, and I was like, well, you know, in Hanauer, and just blank faces across the whole board, and I was like, oh, that's right. I'm usually talking to a very unique sliver of the world that all of us are hanging on updates in the world of insider trading.
Yeah, securities nerds.
It's a better way of putting it. So I actually got to go back to the beginning and explain the story of Panama. One topic that I think sort of surprised me when I left the SEC and entered private practice was that the question I was asked the most, especially my first year, was how does the SEC get its cases? That was just, everyone always wanted to know. I mean, I would like to think my clients weren't asking this because they were trying to do things in a way that the SEC wouldn't find, but they liked knowing how the SEC found things out. And I think in insider trading, that's particularly an area that people are curious about. And under Chair Gensler, and I don't know if it's all because of Chair Gensler himself or more just because of the time and AI evolving, it seemed like the SEC was making more and more use of AI tools and using, cat data and things like that. Ben, is there any, update or information you can give on the tools the SEC is using to find and detect insider trading?
Yeah, well, I'm obviously not going to get into sources and methods and things like that, but I can generally say that the SEC continues to use technology to detect and investigate insider trading. We're going to keep doing that, and as technology advances, one would imagine that our detection and analysis capabilities are going to increase. I mean, I can say that we've put in our litigation releases for cases that at least 3 cases that we brought in the last month, we've noted our market abuse unit, how it has an analysis and detection center, and it uses data analysis tools. I'm not going to get into what those tools are. I probably don't understand them myself, but there are experts on the staff that very much do. You referred to the consolidated audit trail. There was a litigation release about a month ago, which specifically noted that the market abuse unit used the consolidated audit trail as part of its analysis to detect the illegal insider trading activity. Not technology related. I don't think it's any secret because we noted in our public statements that we work with FINRA on a lot of insider trading cases. They refer to us, they refer cases to us. And I think a very common fact pattern that you see in SEC complaints is that there was a FINRA investigation before the SEC got involved, and FINRA sends a list of names to all the people at a company who had access to the non-public information and said, do you know any of these people? And lo and behold, it's like the guy's roommate from college, and they say, oh, no, I've never met that person. And so very often, the fact that someone was less than honest in responding to a FINRA inquiry ends up in our complaint, and we cite that when it happens as evidence of the defendant's scienter. So no secrets there that FINRA continues to be a source of referrals for insider trading cases.
I usually get my cases because someone calls me and says, I just had coffee this morning with the FBI. But don't worry, I didn't say anything to them. But they generally come from, most if not all have been FINRA related, no question about it. And they just tried a criminal case and tried to use the fact that the guy said, the tipper said I didn't lie when I responded to FINRA, that I didn't know the person, and he got on the stand and said that, and he was found not guilty, and the person he tipped was found guilty. It was really interesting. But FINRA, almost all in the 23 years I've been gone from the commission, have come from whatever FINRA does first, then the letter that they send out has generated almost everyone that I've had.
Same here, and there's been a lot of swirl about CAT. I think the Republicans are conducting a comprehensive review of it, and the 11th Circuit struck down the funding structure for it, but it's still in place. You know, to Ben's point, I think it's been cited in a couple of recent insider trading settlements, and it's not the only tool that even the SEC has. There are two other, I think, Artemis and Atlas, and acronyms I don't even know the full names of. But I do think the exchange surveillance, which I think drives the FINRA inquiries, is the core in terms of surveilling and identifying potentially suspicious trading, and that obviously is going to persist through whatever's going on with CAT right now.
And a lot faster now. We used to have blue sheets.
Yeah.
You'd have to send out these blue sheets. It would take forever and ever. Now it's very fast.
Yeah, I think the most shocking thing is the fact that the SEC put out a press release that actually touts the use of CAT in light of the commission then simultaneously or nearly simultaneously issuing the regulatory agenda, where it only highlighted, the only substance that was highlighted in the actual release itself was that there's a wholesale reassessment of the consolidated audit trail. So that was interesting to see. And I agree with you, Michael, and Jim, just in terms of how the cases are being sourced. I mean, FINRA for years, I mean, large option position reports and,
Lopper.
you know, they have Lopper. So, I mean, that is definitely and continues to be a significant source of cases. And Ben, like you pointed out, you mentioned FINRA in the litigation releases, you know, about the cases as well, so it's no secret.
So for our last, you know, couple of minutes, I wanted just to get a sense from our private practice partners. What are you hearing from clients? What questions are you getting? You know, what's kind of top of mind that you can share with us? I thought we'd start with you, Mike.
You know, so Katten has a pretty large group of trading firm clients, and we've got public company clients, and it seems as though that this topic comes up a lot. I actually just had a session with a client on Monday where a trading firm, they've done a deal with a public company, they've got a board observer right now, and with a trading firm that presents all sorts of issues. So how do we do this? And we'll get one-off questions about, okay, we're aware of this piece of information relating to some outstanding indebtedness of a public company. We're also in the equity. Is this material, we're too small to even set up a wall, so put that out of your mind. How do we do this? And so we generally go through, I think, a pretty basic process with them. What is the information? Let's think about how this is going to look in hindsight, because of course it's going to be evaluated in hindsight. How would this trade that you're contemplating reflect relative to your historical trading practices? Is this something that's going to stick out like a sore thumb? What is your overall investment thesis? In other words, were you going to trade in this stock no matter what, and you're just worried about this little piece of information you have? And then regardless, if you do decide to proceed, document what you're doing. And document it really in a non-privileged way, but clearly reflect that you've got compliance and legal involved. And that's generally what we do, is just make sure you've got a good record, that you had lawyers and compliance folks involved, that there was a basis to conclude that the information was not material. There was some other element, market dynamic, that was driving the trading. Otherwise, don't do it. Really don't do it, because at a minimum, you're buying an expensive, stressful investigation. Even if even you get through that unscathed, it's just not a place you want to be in. And the one thing I always tell clients is, if you're left arguing materiality, you've already lost. That is not an argument that you want to try to go head to head with the government on again, in hindsight.
So do you stop short of giving them like an actual opinion that it's okay? Because looking at that Pfizer thing, like, he told his whole company, everyone knew he was going to do it, and he still got charged. I'm hearing you say, you tell them document their decision, but are you telling them it's okay or not okay?
These are, and it's sincerely, it's not a CYA thing. Mm-hmm. These are business decisions. I sincerely believe that. So, we will give a risk assessment, and sometimes it will be, we see very low risk here. We can't give you any assurances that there wouldn't be an inquiry into this, or if subsequent market dynamics change, or unanticipated market dynamics change, that could highlight this trade. But giving a black and white up or down opinion is something that we just don't. I don't think we can do.
I don't. I certainly don't.
You're usually advising on two risks. You're advising on the risk of an investigation happening and the expense, distraction, and everything that comes along with that. And then the actual risk of this being considered material and getting an adverse verdict. But both risks are important, because even if you feel like the facts are such that this is not material and that you would be successful, that's still not a great outcome if it's also going to stand out. It's going to be something they're asking about. There's going to be an investigation. For your average client, winning an investigation and getting a closure 12 months later it's more of a win than not having a closure, but it's still not, the goal.
Right.
Scott, what about you? What are you hearing from clients?
There was a discussion earlier, David Glockner and Shimoil, which I thought was very thoughtful, just in terms of the difference between regulated entities and public companies when you're talking about, MNPI, certainly like for advisors, very specific rules, and then for public companies, it's a very different set of rules that you have to comply with. And for me, at least in terms of clients, I think the echoes of Panawatt are still very significant, just in terms of what policies should look like, particularly from the public company space. Should we have more narrow policies? Should we have more restrictive policies, or should they be broader because we don't want to put our employees at potential risk? What does that look like? I think that there's a lot of questions there, because it's not just shadow trading itself implicates everything from materiality, fiduciary duties, all the aspects of insider trading. So naturally, from the public company side, there's much of that. I think in the advisory space, a lot of it is wall crossing. I mean, that is just consistently continues to be just the questions that you get in terms of where the lines are, how bright they are, and whether or not they have shifted, and will they shift going forward with a new administration. So those are really the two big areas that I'm seeing at the moment.
I think one thing that has surprised me in private practice, because at the SEC, you're getting matters that are going to be under investigation. So there's a red flag, there's hindsight, all of that has come together. And so oftentimes things seem very clear in that investigation, tip that's coming to you. But what's been surprising to me is when you're advising a client at the front end, before anything's happened, without the benefit of hindsight, how much I feel like the clients I work with really do want to get it right, and how gray it actually can be. Is this one piece of information material? Does this mean we can't trade? And they want to do what is right, but they also obviously don't want to not ever be able to trade. So that's one thing that's been just genuinely surprising, is how much and how regularly they are navigating those issues. And until you get that hindsight, it can be hard to tell.
Yep.
All right, any last minute thoughts from you, Ben?
No, I would just, emphasize what I brought up at the start. Insider trading, it always has been a core area for the commission, and that's going to be no different that I would expect from the current one.
All right. Thank you, everyone.
Thank you.
Thanks, everybody.
Thank you.